Hey, Sam, thanks so much, and thanks to all of you for tuning in. You know, this webinar is a little bit different because it's separated into two parts. For the first hour, we're going to talk about what all bank personnel should know about how to handle matters that are considered confidential under federal law or regulation. So it's something that every employee needs to know. And then in the second half of the program, we'll be changing course a little bit. But this first hour is crucial information for everybody within the financial institution, because if you don't know what the rules are, sure is difficult to comply with them, isn't it? So in the second hour, we'll delve a little bit deeper into strategies for compliance with the different laws and regulations that we're going to be discussing. So during the stretch break, you can separate out who's in there, or everybody can stay for the whole thing, and or you can have people listen to the archive later. So I want to talk to you about how this all got started in the first place. You know, when I was counsel for the Oklahoma Bankers Association years ago, something happened that made a huge impression on me, and that is that a guy got a business check from another company, and he called. This was back in the days before GLB privacy, and so nobody had a reason to say no. He called the bank on which the check was drawn, and he said, hey, I've got a check from such and such company for, it was a large sum, like $175,000, and I want to know, will it pay? Well, the person who answered the phone at the bank was very familiar with the customer who had written the check, and without even thinking about it, she laughed. And then she composed herself, and she said, just a minute, let me check. So she pulled up the account on the computer system, and then after confirming that no, there was nowhere near that amount in the account, she got back on the line, and she said, no, sir, I'm sorry, it will not pay at this time. But her ill-timed laugh had communicated volumes about the customer's financial history and financial well-being, so the guy who was the payee on the check called the company that had issued the check to him and said, I just talked to your bank, and this check isn't good. Not only will it not pay, but I got the impression from them that it's unlikely to ever pay. So what happened next was the entity that wrote the check sued the bank, alleging violation of financial privacy because they alleged that the way the communication had taken place communicated far too much, and they won. So there are all kinds of different reasons that you want to understand what has to be kept confidential. And when it comes to basic customer information, our customers treat us with a high degree of trust. They give us their money, they give us their information, whether it's on a loan application, deposit application, or what have you, and they have the expectation that that will all be kept confidential. Then you get into federal law and regulation, and there are specific laws and specific rules that attach a high degree of secrecy to certain sensitive information for governmental reasons, because releasing the information may jeopardize an investigation, may even result in someone's life being in danger, or could cause a suspect to flee the jurisdiction. The real reason that this webinar came about, though, was because of a case involving a banker down in Alabama by the name of Philip Grace. I read about his case in the newspapers and online, and I got a call from Philip Grace one day. Let me give you a little bit of the facts in the case. Philip was a loan officer. He had worked for the same bank for many years. He had a large borrower that had borrowed millions of dollars. I think maybe $3 million was the amount outstanding. On one fateful day, when Philip was walking through the bank, and someone in the bookkeeping department said to him, "Hey, Philip, we got a grand jury subpoena on one of your customers today." And Philip said, "Sure enough, who?" And they told him the gentleman's name, and the gentleman owned companies that produce software and other products for educational institutions like colleges and universities and so forth. And he had a lot of personal borrowings and borrowings of his company. So Philip looked over the grand jury subpoena and looked at all the records that it requested, and he became very concerned because he thought, what's going on with our customer, and what are the implications of this? Does this mean that he's going to have trouble repaying his loans? So he went into the president's office, and he said, "I just found out that we just got a federal grand jury subpoena on this customer, and do you think I ought to check with him, talk to him, find out what's up with this?" And the bank president said, "Well, I guess you should." So Philip called the borrower and said, "Hey, we just got a federal grand jury subpoena on you, asking for all these records on you personally and your company. What's up? What's going on?" And the guy had no idea he was being investigated. And it was in connection with a big investigation into corruption in the secondary education system in the state. So the guy played it cool as a cucumber. He knew darn well what they would be looking at. He didn't know that he was being investigated, but Philip's phone call tipped him off. He downplayed it to Philip and said, "Oh, it's nothing. Don't worry about it." And then he immediately made a phone call to the FBI and said, "Hey, I understand that you're looking at me, and I want to discuss this with you." Well, the FBI was shocked. They could not imagine how the veil of secrecy had been lifted, and this guy had found out so early in the investigative process about the fact that they were looking at him as a potential suspect in this corruption. So the FBI very much wanted to talk to him. And when they did, they couldn't resist asking the question, "So what led you to call us?" He said, "Well, my banker told me he had received a federal grand jury subpoena on me." Everything turned at that point. And suddenly, the target of their investigation became Philip Grace, the banker who was trying to protect the bank. So they went after Philip Grace for obstruction of justice. And in order to get him convicted of that, they asked the bank customer, the borrower, on whom the original federal grand jury subpoena was issued, to wear a wire and meet with Philip. They asked him, "Call him and see if you can get him to give you a copy of the subpoena." So the customer called Philip, and he said, "Say, can I get a copy of that subpoena?" And Philip said, "Well, I don't really know. let me check with the bank president and see if that would be okay. So he checked with the president. The president said, well, yeah, I guess that would be okay. So they set up a meeting in the parking lot, and Philip turned it over to him. The customer was wearing a wire. Philip was arrested. He lost his job. He lost his CPA license. He spent most of his life savings on attorney's fees. They prosecuted him for obstruction of justice, and he was sentenced to